Hello, everyone, and thank you very much for being with us in our third roundtable for the Startup Visa program. We are delighted to have you all with us, and let me start by introducing myself. So, my name is Narmeen Saad, and I am the director of a global entrepreneurship initiative and the Startup Visa program with North Forge Technology Exchange. We respectfully acknowledge that we are meeting virtually on the ancestral lands on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji Cree, Dakota, and Dene people, and the traditional homeland of the Red River Métis people. Thank you all for joining our monthly Startup Visa Program Roundtable, where we host reputable experts in the immigration field to share the latest trends and useful insight around the Startup Visa Program. And this one is a very unique one because today we're going to discuss the new measures, the new regulations around the Startup Visa Program that was a little bit shocking for many stakeholders in the Startup Visa Program. And now we are introducing three reputable immigration lawyers from Toronto who will try to give us more insights about how to pass this, let's say, critical period of time smoothly and successfully. So basically, the agenda for today is that I'm going to start by introducing North Forge, a little bit about North Forge, and then we will start the discussion with the Greenberg and Hamid PC team. And then we will open it for the question and answer the Q&A. And then we're going to go back to the networking stage where you're going to network. You can interact with the lawyers one-to-one on those tables. So at your right hand, you're going to find like a tab that calls the Q&A. Please feel free to add your questions in that tab, and I will keep following up with the presenters. So about North Forge. So for those who don't know what is North Forge, we are a business incubator and accelerator located in the heart of Canada, which is Winnipeg, Manitoba. We are an accredited designated incubator by the IRCC for the Startup Visa program. We are also a proud member of the CTN, Canada Tech Network, which was announced lately by the immigration minister that will have a priority for processing the application of its applicants. Northforge is also privileged to be the only incubator in Manitoba and Saskatchewan that has the Elevate IP program, which is a governmental funded program that financially supports innovative startups for up to $100,000 for their IP financial needs. Let's go to the good stuff and the very critical things that we're going to talk about today and introduce our three reputable immigration lawyers, Nauman Hamid and Alif Maliki and Pushkar Prehar. I'm going to leave it to the speakers to introduce themselves, and then we're going to kick off with the presentation because we have lots of questions and we want to invest in the time. So Nauman, Hamid, and Alif, Nauman, Pushkar, and Hamid and Alif, please open your mic and camera and join me to the stage and introduce yourself, and I will start the presentation. So now, yes, now it works. Okay. So Nauman, Hamid, and Nauman, Pushkar, and Alif, I will leave it for you to introduce yourself to the audience while I am sharing the presentation. So please, Nauman.
Thank you very much, Nermeen. It's a pleasure to be here on behalf of Greenberg Hamid. Very brief introduction because we have a great discussion today with a lot of insight. Nermeen nailed it on the head. It was, I think, surprising for everyone in the industry, whether you're a lawyer, whether you're an incubator, a VC, an angel, an applicant with a case or with a potential case. This is big news. Very briefly, Greenberg Hamid is a law firm. It's led by myself, my partner, Howard Greenberg. We are fairly experienced. We're both certified professionals. Howard's been doing immigration for like 45 years. He doesn't like to admit it. I've been doing it for about 25 years. We're an innovative firm that, although we've got a lot of experience in immigration, we use modern technology and we get really into the issues, and very involved with government policy and then providing services to try to navigate, which has become very challenging. I'm joined today by Pushkar, who is actually one of our lawyers, very involved in litigation. And when things get messy, then Pushkar gets busy in terms of looking at how to resolve issues. hopefully before they actually get to the court. But if we need to go to court, then Pushkar gets involved there. And he's had a number of really great settlements we'll talk about. And then Alif is in front of pretty much all the applications. He's our program manager on a day-to-day basis and has great insights and expertise to share. So without further ado, we'll jump right into the agenda today, which is very full. So we can go to the next slide. I thought what we can do is really talk about the overall strategy that I think we need to think about. So Narbina, I don't know, does it, can you actually go to the next slide?
Yes.
Okay, perfect. So I think the way we'll start this discussion is we're going to spend a little time talking about the context. Canadian immigration, it has gone through a radical transformation in terms of policy focus. We'll explain why, how, and what that means generally, and then we'll jump into the changes that were quite significant. We'll go through what the changes and the announcement mean, when it happened, and then we'll explain to you the context. Our firm has been very involved over the last 2.5 years. We've had multiple discussions with officials, and a lot of these changes were discussed and canvassed previously. Some things kind of fell off the table, and now we see that they've decided to proceed with certain activities and actions. We'll talk to you about the impact. If you are an applicant with a file, if you are an aspiring SUV founder and you are thinking of going into the program, for anyone that's joined that's generally a stakeholder in this particular program, we want to leave you with strategies and impacts that you should think about, because the landscape has changed and you need to think differently about the program. All of the focus has really been on the major change in terms of the cap, but what you might not have noticed is around the same time, there were updates in how SUV applications are being processed and guidelines to the officers, and there are some real game-changing changes that have been introduced. We'll talk about that. We want to make sure you all understand that and see the landscape. We'll talk about adjudications and how applications, whether it's a work permit, whether a PR, how they're being determined and what hot topics have come up that you should be aware of. They're quite interesting. They involve a lot of analysis. We'll go into where cases have been refused and when we've gone to the court on a number of those issues, generally in the industry or ourselves, what the outcomes have been. We can go to the next slide.
Can you see it?
Perfect. We'll go through some case studies, real life case studies, in terms of issues that we've seen and how they've been addressed. There's a number of frequently asked questions that have actually gone to immigration, and we'll share the responses, which are insightful. It tells us how challenging even getting the right answer can be. I think you'll find that interesting. We'll leave off with best practices in terms of what you need to do to be successful going forward, in our opinion. There is another update that's really important for those who are applying or have applied in terms of your settlement funds. They've been increased. So we'll talk about that, make sure you walk away with the new information. We'll look in the crystal ball. We'll tell you what we think the future of the program is. In short, I'll sort of steal a couple of headlines. The program is not closing, but it is in a period of reformation. And we'll talk to you about what that could look like when we get past this period where they're going to be focusing on the inventory. And then lastly, the part that we enjoy the most is an opportunity for all of you to ask any questions. And we look forward to meeting you in the networking. So let's jump into the first slide. And Nermeen, please, at any point, if you want to jump in, we love your comments as well.
Yeah.
So I'm going to start off the initial part of the discussion, and then I'll pass it on to my colleagues. It's interesting, if you look back almost a year to this date, we were approaching the collision conference, and the then minister, Sean Fraser, was speaking about maybe introducing 3-year open work permits and moving the processing faster. And then, in July, there was a cabinet shuffle, and this handsome gentleman became the Minister of Immigration, and he walked into a tailstorm. There became a very significant change economically and politically in Canada. As many of us might have actually felt personally, the price of houses became very difficult to afford and became a significant issue. Even finding a place to rent became very difficult. And there were a lot of concerns politically raised about immigration, unfortunately, about immigration maybe being part of the problem that we're facing politically in terms of housing. Then there were concerns about whether the door has been opened too widely and without safeguards. So a lot of criticism about Canada's student visa program, a lot of private colleges opening up programs, bringing a lot of students. Many of you might have seen the news reports where unfortunately a lot of students came in. They weren't getting the schooling that they were promised. As a result, they were having difficulty making ends meet, going to job food banks, struggling to get employment, sometimes not even studying, although that's what they were authorized to do. So that raised a lot of concerns. And then there was a concern generally, have we let too many foreign nationals in? And so there's been a discussion by the minister. Now he's introduced a cap on the low skilled worker program. He's talked for the first time in years that I can remember the idea of lowering the number of immigrants into Canada. Every year we've been increasing year over year because we desperately need the skills. Now, because of this political pressure, he's talking about potentially, decreasing the numbers for a period of time. So the program's constantly being analyzed, and this is a time of review restriction. And so if we move over to the next slide, we were not entirely surprised, but it's always when you wake up and you read on the 29th of April that these changes are being introduced. It was a little shocking when we actually read, and immigration, following their usual protocol this day, gave us 1 day to digest this news on April 29th for implementation on the 30th. And essentially they went back to first principles, which is that they want to encourage all the designated entities, the VCs, the angels, and the incubators, to focus on the highest aptitude SUVs. And how have they done that? 2 ways. Number one, they've capped the number of certificates that a designated entity can issue to 10 per year. Okay. So if you keep that context in mind, and Pushkar is going to go through some numbers with you. In the past, there was no cap. So there were some high volume incubators that would issue, 100 or 120 a year. All of a sudden, they've leveled the playing ground. It's only 10 for each entity. If you're an entity that has 2 streams, a VC and an incubator, for example, you're limited to 10 in each one, and you can't move those certificates between those different programs, and entities cannot share certificates. You use them or you lose them. Alif will talk to you a little later about all of the sort of takeaways from this announcement. But that was significant. It basically has really created some shortage of certificates in the marketplace because of this cap of 10. The other introduction they focused on is priority processing. So currently, we know the processing is fairly lengthy in this program. They've suggested in their announcement that they will prioritize those companies that receive funding. So VCs and angels get preferred processing, as do incubators that invest at least $75,000. That's one group. And if we go to the next slide, I'm going to focus on the other group that gets priority processing, and a shout out to North Forge because they're on the list. So if you have been by Canada's tech network and they have validated you and approved you, then this particular group of 9 are also entitled to priority processing with regard to their certificates. And that's a big win for the individual entities on the group, because there's a moratorium right now and no other entities will be added on the list until we get past this initial period where a new announcement has been released. So if you step back, they've lowered the number of certificates and they're going to move faster where there is funding with regard to the entity that's issued the certificate, or if it's an entity on one of these listed companies. For other applications, they'll still be processed, but they won't get the priority processing. So that was the big news. Let's go to the next slide. and step back a little bit, and I'm sure many of you probably wanted to know, why did this change come into play? The program had been running for a long time without many changes other than updates to operations, occasionally some updates in the ministerial instructions. But the big problem that the program faced was, number one, when this program was introduced, it was designed only as a PR program, moved very fast. Applications that were selected, often individuals were permanent residents within 3 to 6 months. It had ballooned up to 37 months. And Pushkar will show you with some data how we got there. And so that was never the intention. The volume became very significant, probably resulting in some of the errors that we see. They were not built for this program to be this high volume. The second factor was, this was supposed to be high quality, high touch companies that were being processed, so that Canada ended up getting some amazing companies that were going to sort of innovate the marketplace. It turned into something quite different, where it was at times questionable companies, not necessarily sure that they met those requirements of what was intended, but it became high volume. And so these implementation changes were designed to address both of these issues. And then thirdly, I can tell you, with our discussions that we've had over the years, there was concern too about the genuineness. And we'll talk about some federal court interpretation on artificial transactions. There's a provision right on point. But because of the volume and because of the enthusiasm of people wanting to come to Canada, there were a lot of applications where it was getting difficult to understand if they were genuine or not. And so I would say the combination of these three factors resulted in the changes. I would tell you, looking back at it, it's interesting. We had ongoing discussions and 6 policy papers with immigration officials, and many of these ideas were discussed in the past. So a cap of 10 was discussed from a number of SUV policy analysts some time ago, and then they moved away from that. They thought at that time that it was maybe too extreme or not necessary, but that was canvassed. They talked about limiting the certificates to certain sectors only. That became challenging because most of them are in the IT sector, so it was hard to segregate. And it seems like they did take our recommendation that companies that either have funding or that have some degree of traction, it makes sense that they would move faster through the processing. If you think of the startup, reality, companies that have money typically have established validation, and those are the companies that you would want to fast track. We were hoping that what they would do is create a scoring mechanism to look at a variety of factors similar to express entry, and by invitation, select those companies that demonstrated traction and growth, but they weren't there. We'll see what happens over this 2-year period, but some of these requirements were anticipated because of past discussions. I think they went back to the cap of 10, and Pushkar will show you, because it was like a curve that just went straight up in terms of the number of files, and they had to do something to be able to deal with this backlog that was going to be insurmountable at the current pace. So that's really the background there on the changes. I'm going to pass it over to Pushkar now as we talk about why these changes occurred, to do a little analysis about the growth of the program. So over to you, Pushkar.
Thank you, Naman. Narmin, maybe we can go on to the next slide. Just stemming from what you just mentioned, Naman, with respect to the policy papers that we had advanced to the minister's office at numerous occasions, you'd see that here there's a redacted copy. It's we didn't mess up the slide. This is actually redacted as how we received it from the government. You'll see that it discusses 2 major concerns. One was with respect to certain litigations, because, well, there was a coding error in some of the work permit applications that we've discussed previously in numerous presentations. And 2, the growing inventory and the impact on the multi-year level plans from 2023 to 25. So I haven't provided an entire copy of it because most of it was redacted, but the interesting part is on the next slide and the slide after that. So Norman, maybe we can move there. Yeah, just the next slide. That's right. Yeah, that's right. So what transpired, if you look closely, you'll see that in 2022, the department received approximately 13,000 applications, and that's an average of 1,100 per month. Now, I want to pause there to mention that this is the data that is recorded, right? There are certain applications that were filed in 2022 or 2021 or even 2020, which hadn't been opened as yet. So the IRCC had not really evaluated. So even if you look at the data as it stands, that is 13,000 applications in 2022. That's enormous on its own. But imagine the number of applications that some of the lawyers or consultants who are here, or some of the clients who may have filed these applications at the time, which are who haven't yet received their AORs. So if you contemplate those, the number is far more than the government ever anticipated. So the resources weren't enough for the government to open these applications and start processing them. You'd see that this is a memo to the minister. So they write that the federal business target was only 1,000, which was equal to an average of 82 admissions per month, as opposed to 1,100 per month. So therefore, there was a misalignment between the intake and the number of applications that they could ever process. So that was one of the reasons as to why these changes had to be brought in. We can move on to the next slide. And if you look at the projections that they made for 2023, this is sometime in 2023, this memo, but they projected that there'll be somewhere around 36,000 applications under the startup visa and self-employment category. And they mentioned that this will definitely not be they will not be able to process this in the coming years, and the inventory will just keep on growing. And therefore, at the time when we looked at the processing time to be just 6 months, like Naman mentioned, it grew to 12 months. Then we saw a gradual change to 16, and then they said 24, and then 32, and now we are at 37. The reason that it kept growing was the number of applications that were being filed. And we are all aware that the reason that these applications were growing was because the intent behind the program was to bring in entrepreneurs who had a great idea, and you could pitch the idea to the government and create significant economic and social and cultural benefit to Canadians. But what transpired is that there were a number of players that stepped into the market and started creating these fictitious businesses and started flooding the startup visa program. Therefore, the minister, of course, had to take on certain extreme measures, and we saw the announcement on the 29th. We can move on to the next slide. You'd see the number of applications that were processed by each designated entity. I don't want to get into the real numbers. I just want to discuss and show you that if you see from 2014 up until 2023, we have the data up until towards the end of 23. That's on the next slide. You'd see that there is a gradual change in the number of applications that are being processed, and there's also a huge change in the refusal rates. And this is of course permanent residency. The work permits were being refused at a different tangent. And what we've gathered from this data is that because of the increase in the inventory, what the government started doing is they started perusing these applications at a faster rate to get through them. But the unfortunate impact on a number of these applications was that they started being refused because of a variety of factors that we'll discuss in the future slides, where we talk about refusals and reconsiderations. So that's a bit. I think, Noman, if you'd like to add something to the stats that we've just seen.
Yeah, I mean, when we looked at this too, what you would see is that from year to year, the number of cases they were able to process in a yearly basis was so disconnected to the number of cases that they received that it was carrying over. The processing cases that should have been done, if there was a reasonable balance, carried over year. And we've seen this in the past with other immigration programs, where I remember one time, previously before express entry, when you applied as a skilled worker, it was taking over 7 years to be able to obtain permanent residence, to even get your case looked at. And that's when they overhauled the system and created express entry. And so from past experience, when you get to a point of system failure and being able to keep up the processing, this is what causes unexpected announcements. So I think that's a good context there.
We can move on to the next slide. Yeah, and maybe even the one after that. So in brief, these are one of the reasons as to why, you know, the minister came up with these changes, and why we think that in our opinion it may not be the worst thing. To be honest, we have clients who've been sitting in the pipeline since 2020, and the applications are yet not processed. These are real businesses, and businesses that are actually creating a significant impact on the Canadian economy. So by limiting to ensure that the inventory is processed, it may not be the worst thing, at least as on date. Yeah, maybe we can discuss the impact of the new changes.
Sure, and thanks, Pushkar, for the analytics. It's very helpful to see kind of the trends and the future projections as well. And part of that is, you know, the impact that this announcement is going to have. And so, you know, the 10 cap per designated entity, it's to reduce the intake so that they can focus on the backlog. And we're expecting that this is going to speed up processing, which is good news for people who are currently in the pipeline, but also people who are looking to apply now. Although it'll be a little bit more difficult to get a certificate as an applicant, because the entities are going to have to be a little bit more selective with picking only the best of the best. It will result in faster processing if you know, IRCC definitely kind of meets their intention with what this announcement was for. And so the cap, again, just to summarize, it's only 10 applications per organization in the year, so they can't carry over. You can either use your 10 per year or you lose it. The prioritization of processing will be for applicants who have that funding that Noman mentioned previously, or if you have a certificate from one of the entities listed on the Canada Tech Network, which North Forge is part of. The impact on the designated entities, again, they'll have to be more selective with who they issue their certificates to, because now your certificates are essentially golden, right? These are the most valuable things that you can get in immigration under this program. If you don't have a certificate, then you have to look at alternatives. And we've seen a lot of that happening recently as well, where we're working with clients who, you know, perhaps may not meet the requirements to get a certificate, but they still have a really good business idea. And so we're working with them to try to find alternatives to bringing that company to Canada. And so, yes, go ahead.
That's a really important point. I just want to add a little additional information there. What we're also seeing is that, and it's happened quite quickly, there is more scrutiny on the designated entities in terms of their due diligence, and we've already seen that. And, you know, I think because we're now limiting the number of certificates, and the officers are going to be focusing more on the adjudication side, you may notice that there are going to be entities that face additional scrutiny. We've seen that where there's direct questions about the degree of the due diligence, whether industry standards were met, and in some instances too, really looking at even their process of how they transmitted the certificate. Was the certificate complete? And so for those applicants too that have received a certificate, you should be aware that, you know, you're going to have to ensure that you really need to understand the designated entities, processes, and their reputation. And when you're selecting an entity, pick carefully, because the scrutiny will be very high. Pushkar will later on talk about the process of peer review and, you know, the impact it can have. Ultimately, if the officer is not persuaded that the standard was met, that could be a piece of evidence that results in a refusal. So I just think there's going to be a lot of scrutiny, and going forward, there are only 10 certificates per entity. It'll be very clear for IRCC to know who did that designated entity ultimately select and what were the terms, and they'll be able to get a really good sense of how well the entity is doing the job. So back to you, but I just wanted to make that one point, Alip.
Sure, yeah, no problem. And so if we actually go to the next slide, we have a sample letter of support, which is actually very interesting now, because this is where we're going to see an actual change in the processing of the application. And when you're preparing the application as well, if you're an applicant, consultant, lawyer, whoever you may be, you'll see that there's now a commitment certificate number right in the middle of the form, which wasn't there previously. And so this certificate number is issued within the limit of 10 per organization. And so each one will have a unique number, and then you would put that unique number into your PR application as well, which is also reflected in the portal as of April 30th. They actually added a new section that says, has your commitment certificate been issued on or after April 30th? If you select yes, you'll have to input this number. And so that's how IRCC links your application to your commitment certificate. And that's how they also keep track of how many certificates are being issued by the designated organization. Now, this is very important because previously there weren't any certificate numbers. It was an unlimited number. There was no unique identifier. And so a lot of these cases, when you submit your PR application and it goes into this immigration black hole, you don't really know what's happening with it. Whereas now you can have a direct linkage to whatever was submitted to IRCC by the designated organization and whatever you're submitting with your PR application. I think this is also a very important step in IRCC changing their technology to try to process quicker as well. So now you won't have to wait for an officer to actually go into your file, click it, look for the certificate and find it in a pile of thousands. Now they can directly link your letter of support, your commitment certificate, to your application. So it is a step in the right direction, I think, in terms of quicker processing and leveraging technology. But again, it does limit the amount that you can do with that one certificate. If you had to get a second certificate, let's say your application was refused and now you have to reapply, it's going to be much difficult to get that second certificate number, and then reapply. So that's just something to be aware of. And we'll speak about that later on in this discussion as well. And if we go to the next slide.
So maybe I'll just give you some context. Everyone was focused on the cap and the priority processing. But if you watch very carefully, around the same time, there were updates to the operational bulletins for officers on how to process SUV applications. And there are some very significant changes that everyone, definitely, I want you to all take this away. The first one, and interestingly, in the guideline, it doesn't clearly stipulate the date, the effectiveness date of this first provision. You'll see at the bottom of the document, they have an older date, but clearly this is a new provision, but it doesn't tell us clearly when it will apply. We know going forward it will apply, but it doesn't explain if it's retroactive. And it says this, that only officers must only accept updated commitment certificates until the receipt of the first SUV PR application from any member of the entrepreneurial team listed on the certificate. The receipt of the first permanent resident application will serve as a lock-in date for the commitment certificate, at which time no further changes can be made. So once one member of the team files a PR application, that certificate is locked in based on this policy guideline. Now, in the past, you would see that many times applicants would go through changes in their business. Perhaps they would add a new member, remove a member. Maybe they would change the nature of what the business was going to do. They pivoted. These things happen. And it was quite common to then go and get the certificate updated so that, ideally the officer, when they see the changes, it's in line with what the designated entity is aware of, and they essentially validate that action. This took us by surprise because they're saying that at the time that you file one PR application, you're locked in. Now, in a scenario that we've seen to date where it can take 37 months, not really reasonable in my mind that a business wouldn't change significantly. And I would think it would be reasonable to update the certificate, but given this new guideline, you cannot, right, update the certificate. Now, in our opinion, you still need to explain the change very, very carefully. And that change, in fact, will probably conflict with your certificate. So there's a legal analysis we've done on how to find that balance, but it also raises a very interesting legal issue retroactively. Can they apply a policy retroactively? And number two, this policy is not supported by any regulation that speaks clearly about updating. So this is a Pandora's box. And I would say if you're in a situation where your business has changed, and you feel like it's disconnected with your certificate, or you previously amended your certificate, then you should definitely seek some counsel on that, because this is a hot topic. So that one's a little troublesome, but we should at least know what the policy says so we can consider the best strategy. The next two are actually good clarifications. When an essential member has obtained PR from another program, the officer can place the SUV application on hold pending assessment from the rest of the group. If all the requirements are met, the officer can approve the rest of the group before withdrawing the PR in the other category. So I think this is a good clarification, because what we had seen in the past is that you might have a group of 4, and sometimes one member, without telling the others, would file for express entry. And they were still potentially part of the business, but then there was an automatic election that occurred in the IRCC system. And once that essential member, for example, was processed in another category, all the other members were refused, which, if you think about it, doesn't really make sense. If they're still working on the business and committed, PR is PR. How you get it really shouldn't matter in my mind. And so this is a good clarification, which means that an individual can in fact seek PR in another stream. They still must meet the responsibilities in their certificate, be actively involved, maintain their shares. All of that should occur, but it means that it allows people to participate in the SUV program, but potentially consider other PR streams as a backup plan. So I was happy with that clarification. It never made sense to me that they would do that. And the other one, which is really like sensible, is if essential team member passes away, you can place that individual's application on hold pending assessment of the rest of the group. And if all the requirements are met, then they can withdraw the person who died, because obviously they're not getting PR anymore, and can approve the rest of the group. Now, keep in mind, if the person that passed away was the CEO, then you still have to demonstrate how the rest of the group can function, but it's not an automatic refusal. Remember, if one essential member is refused, the normal rule is the whole group is refused. These are exceptions now, not talking about refusals, but about individuals no longer participating to the end of the program. So those are good clarifications. We'll move over to the next discussion, and this should be interesting. Instead of going through lots of different content, we thought we would just do kind of spot the issue. These are trending issues that have happened, and we'll give you sort of a short summary of what the issue is, and then kind of what the takeaway is. So maybe I'll turn it over to Pushkar if you want to start in covering a couple of the items that you've been involved in, then over to Alif, and I'll finish off.
Right. I can. I'm just going to pick a couple of these. This is very interesting for me. A couple of months ago, I'm going to start with IRCC random calls. All right. So a couple of months ago, we were approached by some clients saying that the IRCC officer who was processing their application called them, and they had a number of questions for them. Questions such as, how did you contact your designated entity? What is your relationship with your co-founders? How did you meet them? Who paid your processing fees? Because I see that the name on the receipt is someone else's. Do you know this person? What are your intentions? Tell me something. Give me a 5-minute pitch of your business. Explain the business to me. And based on those conversations, they were issued PFLs, and they were asked directed questions to say that, and of course there were certain provisions of the Immigration Refugee Protection Rules, such as Section 89, talking about artificial transactions, among others, cited to say that I don't really believe that you're in this business for the business, and you really want to gain permanent residency. So that also is happening, and we have at the time advised the client to either mention that they need counsel with them to answer, or alternatively say that any questions that the IRCC has, it's best that they put it on record by sending you a letter, and then maybe your counsel can respond to it. One of the reasons that we mention that is because it's always better to document and to clearly articulate what your response is. Now, if someone asks me the same thing about myself as to what my relationship is with a co-founder, I would of course mention what comes to my mind, but there are certain nuances that I need to be aware about, because these questions are not being asked from a perspective of a general interview. These are pointed questions to ensure that there is no fraud that is ongoing within the program, and especially with the applicants. So that's one of them.
Pushkar, let me add to that. When I looked at a couple of the scenarios where I felt that the process was procedurally unfair, is that the way in which the officer approached the individual, it sort of disarmed them, saying, "Oh, I just want to obtain some general information." They're very, very friendly. In fact, the applicant said, "Oh, I didn't think there was anything going on." She was very friendly. But when we saw the procedural fairness letter, they were acquiring evidence basically to attack the credibility. And the individual was, in some instances, in transit, picked up the phone and is trying to was not, ready to talk about the details of their business. And they were asked very pointed questions. And they didn't appreciate that these questions are forming the basis of evidence that would then potentially result in a refusal. So our first recommendation to anyone is, you are not required when you receive that call to answer. And we would suggest that you say, "I'm not in a position at this time to answer the questions. Can I please set up a time to call?" Or to Pushar's comment, "Can you please send it in writing?" But first, talk to your advisor. Make sure, if you are going to engage, that you understand and refresh your mind on all of the provisions. In some cases, you might be trying to recollect and you recollect incorrectly, but now it's on the record. And when there's a number of inconsistent statements, that's how they question the genuineness, and they could lead to a conclusion that's an artificial transaction because of the evidence you gave while you're going for groceries, right? So the point is, expect that these calls can happen, and don't be caught off guard. And all of your team members should be aware of it. One essential member gives the wrong information, everyone's refused. So that, just a little context there, Pushkar, to that IRCC random call issue.
Well, there's so many others. Okay, I'm going to talk about another interesting one. That's transmission error certificates. So, and this is not the first time that we got this within the last week. So maybe within the last month, we received consultations. We did consultations with 3 sets of clients, 3 groups. And it appears that certain designated entities did not send in the commitment certificate to the IRCC at the time when these applications were filed. At times, the commitment certificates had certain errors in them. At times, the commitment certificates were left blank. So the question, and of course, the IRCC officer who was processing the application towards the fag end of the processing, so 3.5 years down the line, sends a PFL saying that, "I'm sorry, I didn't receive the commitment certificate from the designated entity. Can you please respond to this? Because as per the regulations, the designated entity has to send it to us, and then we will verify based on that." In some of them, there was a PFL. In some of them, of course, there's a refusal, and we are filing a reconsideration. Some others we've challenged before the federal court in light of various, arguments such as, well, okay, let's not get into what the arguments are, but if you've also noticed this, we've seen, unfortunately, there are certain designated entities that have done this quite a lot. And in our opinion, there may be a class of people or groups of people during a certain time duration, say in 2021, 2022, or even 23, where for 6 months, 7 months straight, the certificates weren't really sent, because somehow the people who were there in the designated entity at the time, who were acting for the designated entity, the employees, maybe weren't aware or weren't trained to do that. And because of that error, there are now more than 50, 60 people, or maybe even more, who are being impacted by such a situation. So if you've also noticed, or there has been a similar issue on your end, or if you are a lawyer or a consultant who's been, you've approached clients have approached you for this, you can reach out to us. We have come out with a number of ways in which we are arguing this before the federal court and before the IRCC, and also we are trying to create enabling a group litigation before the federal court. So I just wanted to put it out there so that we can start conversations regarding this particular topic, maybe off the seminar, and you can reach out to us.
I'm going to add a comment, Pushkar, because it's really important. We were shocked at how often there have been either transmission errors of the certificates from the designated entity to IRCC, meaning that the email record was not there. IRCC came back saying, we don't have a copy. And then the entity, for whatever reason, could not track that they sent it. In some cases, they had a certificate with the date, but they couldn't prove they sent it. In other cases, it wasn't clear to us that they actually had even properly prepared the certificate, but they had, ultimately issued a letter of support. So the applicant felt quite comfortable that I'm in a good position, the process has been completed. The applicant doesn't have the visibility to know that the certificate was in fact transmitted properly. So if it was me, right, and I was an applicant, given that the trend right now in the issues, I would want to confirm with my entity some sort of confirmation that they in fact sent it. And you may see there are certain entities that are having this issue. And if you learn that you received a certificate from an entity that has that issue, then you should definitely seek advice, because we have looked at the regulations. There is room to argue where you have not committed the error from the applicant's perspective. It's been done by the third party. There are ways to try to protect your interest based on the merits of what you've done. But you need to be able to identify the risks and, of course, try to get that on the record so you've got a position that's compelling for the officer. But this one is a hot topic, and Pushkar's point, I think there's going to be a lot more focus on that issue. And maybe you might want to get into, because it dovetails on the same point, the due diligence perspective, Pushkar, as well, in terms of inadequate due diligence.
Well, yes.
Can I add something here? Can I add something? I just want to tap in here for this specific point, is that when we send the commitment certificate, letter of support for the IRCC, we're supposed to have like an automatic reply that this has been received. And I always keep this acknowledgement in the file of the applicants as a proof that we have already submitted and everything has been received. And it was like one error, so that for any designated incubator, we have to be careful, is that for one of the applicants, they were 5, and I submitted, and by default, okay, I copied paste that automatic reply, but I just looked, and it was the only one that says this was not received, because the documents were very large. So I had to go back to the PDF and then just like resize it to make like a shorter so that the system will accept it. So these things may happen. And again, this is very good point to be pointed, so that the applicant has to be clever enough to go back to the incubator, ask them, please, can you provide me with this automatic reply? Because we can't do that. It's an evidence.
Absolutely right. And I like that you're actually into the details about the confirmation and keeping a record. What I've noticed so far, we've noticed as a firm, in some instances, it's where entities are issuing certificates very quickly in high volume, and there's high turnover in their team, meaning people are coming and going. This is where they don't have a centralized process, which we've always recommended. They're not retaining documents in an organized fashion, and no one was really checking. And when you have a 37-month period, you only find out 2.5 years later, and guess what's happening? They're looking. So I think, Nermeen, you're doing a great job of looking at the details, particularly concerned about some of the bigger players who've been moving fast and loose. They're the ones where if you've received your certificate, I would be particularly concerned. But yeah, make sure you have a good relationship, good partnership with your designated entity, communicate. Things can be potentially addressed if we're all transparent. It's where no one knows, or we're not sharing the information between entity, applicant, and lawyer, where we don't have an opportunity to fix it. But thank you for that.
We were at, I think, I'm going to take maybe one or two more together, and then I'll pass it over to Alif. We can talk about due diligence. So as we are all aware that the designated entity needs to conduct a due diligence of the business and the applicants prior to issuing the commitment certificates. We are given to understand, which is a little shocking for us, that certain designated entities are issuing the commitment certificates and then doing the due diligence. We also given to understand that there were certain designated entities who've charged for doing a due diligence, which is per the regulations not permitted. There's also another issue that we've noticed recently, that the officers have taken the view that due diligence was not performed because the commitment certificate does not list certain eligibility requirements right out of the regulations. And of course, that was promulgated by the minister under ministerial instructions. Common example being, the percentage of ownership of the business. So what the ownership structure should be. At times, there are this kind of information which is very vital to the commitment. If it's not listed in your commitment certificate, or it's not provided by you or your representative to the IRCC at the time when the application was previously filed, it may be 3 years ago, then the officer may take a view that, one, this due diligence was not performed, and two, you may not even meet the requirements of the Startup Business Class program. So we've been recently approached by a number of people who are facing this issue as well. If a similar situation has arisen with you, then it may be worthwhile getting a consult, and we can walk you through the specific facts of the case. After looking at the specific facts of the case as to what the argument may be, it's unfortunate that a number of these issues are not coming up because of any, for the lack of a better word, fault of the applicants, but of third parties. And after going through the process for a period of 3.5 years, waiting for your application to be processed, and with the new regulations being, with the update, and now the IRCC being faster with the processing, we're going to see a number of these refusals coming in only because of not meeting certain criteria, which to begin with was not in your control, even after submitting a composite application from your end, at least as the applicant. So that's another thing that you may see, and you may call it unfair, but one of the only options that's left to you is either to take it to court, or prior to that, set it up for federal court litigation.
I'd just add to that. In some instances, some triggers that you should be aware of. If you received a certificate and there was very little questions asked about your business, if you didn't meet anybody, any mentors, any third parties, if the process seemed like you paid and you received your certificate within a couple of days, those are red flags, right? Normally with proper due diligence, there should be a period where you have to demonstrate your innovation, who you are, that you meet the regulatory requirements, what your plans are, should be detailed. But there is a fact pattern where some entities were issuing these certificates very quickly. Applicants often didn't appreciate what is the requirement of due diligence from an SUV perspective. So you may not have been aware that that's not normal. The problem you face is once that issue comes out on a designated entity, then it's likely that there's sort of additional focus on that entity going forward. So what you want to do is make sure, even if due diligence wasn't done properly, you have an obligation to demonstrate what you're doing. And then there could be arguments that we can consider, but definitely that issue. And I'll just sort of finish off one before we give it over to Alif. Peer review. I think these will be very hot topics. Peer review started off quite regularly when the program got busy, and then it tailed off, primarily because probably officers couldn't keep up. As they're dealing with the inventory, as some of these issues are occurring in terms of deficiencies, I think we're going to see more peer reviews on the quality of the due diligence done by the designated entity. And I think that additional scrutiny will result in more refusals. And so it's a good time to really get a health check on your file, because I think we're moving into a level of higher scrutiny. Maybe this is a good time, I think, to pivot over to Alif to talk about a lot of the areas he sees in the program and the hot topics on the processing and activity side.
Sure. And so, yeah, part of that peer review process is whether a officer believes that you're doing enough, right? Because it may raise flags that, okay, maybe this business isn't genuine, or maybe they don't have a viable business plan to actually operate and be successful in Canada. And so part of that is continuously updating your business plan. And that's becoming more and more important to do, because as your startup goes through this journey in Canada, um, your timeline is going to be reduced because of this change, right? Because they're going to process these applications quicker. Currently, it's taking upwards of 37 months, but we anticipate it could be as short as 1 to 1.5 years, depending on how quickly they really do process these applications. And so, if your timeline is now shortened from 3 years of processing to 1.5, you really have to be able to show that you've done enough in your company, that you have a viable business plan, and that you're always kind of changing and updating your business plan, not with significant changes that would require a new certificate, but just to kind of react to the market. So if you come to Canada on the work permit and you see that, okay, maybe we should do this instead of that, then you would update your business plan, and you would show projections as well to say, based on our current activities that we've done in Canada so far, this is where we anticipate 2024 is going to be like, this is what we anticipate 2025 is going to be like. And then you would submit that to IRCC so that they're always kept in the loop as well. So always updating your business plan, updating your file as well with IRCC is becoming more and more important, just because you're not going to have as much time to kind of wait around and see what happens with your business, because your application's in the pipeline with 30,000 others, right? So it's definitely more important now to use your time wisely. That's one of the hot topics that I wanted to discuss off of Noman's, but another is work permits. And I think work permits kind of touches upon each one of these in one way or another. The essential versus non-essential argument, whether you should list all your members as essential, whether you should keep some as essential and some as non-essential. There's a lot of considerations to be taken here. One of them is your risk factors. And so if all members are listed as essential, you're all in it together. So if one PR application for an essential member gets refused, the entire group is going to be refused. Because if that one essential member isn't able to come to Canada and work in Canada, then they're essential to your business. The whole thing kind of falls apart, right? That's the argument that IRCC makes, and that's what's in the regulations as well. And so it's very important that you really pick and choose your team, and you work with the designated organization as well in who you should list as essential versus non-essential to your business. Non-essential members, obviously, they do not get a work permit currently, but they can help provide support and do whatever work that must be done in their capacity from overseas, from outside of Canada, until they get approved for PR. The non-essential members, if they get refused, then the essential group, whether it's 2 people, 3 people, whoever is listed as essential, they will be unaffected by a PR refusal for the non-essential member. So that's your way of kind of working with your team and structuring your team and the certificate to minimize your risks. If you believe that there's someone who isn't urgently required in Canada and can do their job from overseas, then you should consider maybe listing them as non-essential, because it significantly reduces the amount of risk that the entire team has that's listed as essential. Another kind of hot topic is whether you should file your work permit or not. And so as essential members, you have the option to apply for a work permit, but it's not actually mandatory that you do so. That being said, we always recommend that you do apply for the work permit so that you can show that you have a reason to be in Canada. If everything that you do can be done from outside of Canada, you don't obtain the work permit, but you're listed as essential, the IRCC officer could definitely flag that case and say, well, I mean, if you can do everything from outside of Canada, what's the point of granting a permanent residence visa? And we've seen that happen previously as well. This was one of the older cases from, I think, 2023, like very early on, I think January. So we haven't seen that come up since then, but it is something that they have issued in the past as a refusal letter. And so whether you file your work permit or not, I would always err on the side of doing as much as you can when you do apply for your work permit and you come to Canada, versus not, because the benefits, I think, outweigh the risks. And so another part of that is dual intent. Pushkar, I remember you wanted to speak about dual intent. Is it okay if I lean on you for a bit?
Yes, please go ahead. Yeah.
Go ahead.
I'm actually, what I'm going to do is I'll cover this in the coming 2-3 slides with case law.
Sure.
I have a number of things to discuss. Yeah.
Right. Okay. No problem. Then I'll go to work permit extensions, which I know you're also covering, because they are a very hot topic right now as well. Because there has been a very high rate of refusal for work permit extensions, and part of this is because there's no actual regulation or ministerial instruction that speaks directly to extension of work permits. And that's because when the program first came out, it wasn't anticipated it was going to be 37 months long. And so if you're only able to get a 1-year work permit, which is currently what's listed on the website, obviously you have to budget for the other remaining 2 years of processing, right? And so you're going to eventually need a work permit extension. And so these extensions have been processed in a number of ways, but recently we're seeing a lot of refusals on work permits. And the reasons, quite honestly, in recent months, they've been all unreasonable, let's say, right? So sometimes we get just very random off-point reasons for refusal, such as you didn't submit your letter of support with your application. That's a very common one that we see. When in reality, the letter of support is probably the main document that an applicant would submit with their application, especially being under this program. You work so hard to get the certificate, you're most likely going to include it with your application. And so some of these refusals, they're kind of off point. Even the ones that mention something of substance, we've noticed that there really isn't any merit to it. And so we've been successful in reversing a lot of these. And so what our advice is for work permit extension specifically is not to wait until the last minute to extend your status because of this high threshold of refusals. Ideally, you should apply for your work permit extension with enough time to budget for processing, as well as a potential refusal, so that if you get refused, you still have some time left on the current work permit to resubmit your application with whatever information was perhaps missing, or to address any of the officer's concerns in the second application. You don't want to be stuck in Canada on implied status and then get a refusal and then have to restore your status or leave the country. Especially as a business owner, it can really sidetrack your business and delay a lot of processes that you currently have in Canada, and that could eventually impact your SUV PR application as well. And so, Pushkar, I'll hand it over to you to talk about the next section.
Thanks, Arif. And I think you've covered many of those, and I'll be talking about some case laws that are directly impacted by these hot topics. We can move on to the next slide now. All right, so we're going to go over certain case laws, but I'm going to be brief about it because a number of these we've already discussed in the previous slides. These are coming straight from case law of the federal court. Like we mentioned earlier, now if you we just discussed the fact that whether you need to apply for a work permit as an essential member or not. And Alif opined that, and it's that if you are an essential member, you must apply for a work permit and at least show that you are engaged in the business inside Canada. And like the regulations say, an essential part of the business is being performed inside Canada. That's very important. The court in a 2019 judgment said that if you are in Canada on a work permit, then work on your business. Show the officer that you're doing something for the business, because at the end of the day, this is a startup business class program. You can't be on a work permit inside Canada and not do anything on it, or be on a work permit and leave the country and not do anything on your business. You need to be actively engaging with the business. That's very important. There is a very important judgment of Justice Diner, which talks about this case discussed a number of things that also it comes on the next slide. I'll just cover it in brief. It talks about the applicant filing a work permit and being refused on the ground that your purpose of visit to Canada does not make sense. You do not have sufficient family ties outside Canada, so the officer felt that you may not go back to your country of residence without really engaging with the intent behind the program. So Justice Diner carved this out, and we really love this. We use it in a number of our submissions. It's a classic example of a dual intent. Essentially, the startup business class program is a permanent residence pathway, right? The work permit was an option that was introduced because the timeline went on from 6 months to now yesterday's update to 38 months. So during this duration, if you want to enter Canada and start working on your business, so that by the time your permanent residency is granted, you have, your business has reached a specific stage, because 3 years is a long time for an application to be under processing. Therefore it was introduced. So the officer can't, what the court held is that the officer can't really refuse the application on the ground that the purpose of visit is not consistent, because the applicant will not go back. It's completely unreasonable to say that the applicant will not go back when the applicant is applying for permanent residence in the first place. We can move on to the next slide, Narmin. It's we more or less cover a similar footing, and on this also, it's around the same lines based on family ties and purpose of visit, that the officer cannot just refuse it on that without any further explanation as to why they feel. There should be something in addition to it, right? It cannot be just, it's not just any other temporary resident application, such as a work permit, which is actually of a temporary nature. But at the same time, the courts have also, the jurisprudence has flown since there, but the court has also held that it's still the applicant's responsibility to show that they will abide by the conditions of their stay. So in a given situation, as a fact pattern may be that there is a startup visa applicant who's applied for permanent residency and now is filing a work permit application, has been deported from the US for overstaying, and the officer refuses on the ground that they may not go back because of this deportation, which the applicant may have even disclosed, then that reason may still hold good. But if that is your situation, then you need to make sure that you're providing arguments to say what were the circumstances in which you overstayed in the US and why you were deported, and how you've shown after that, after your extensive travels to maybe other countries, or how can you now prove that you're not going to overstay your temporary residence in Canada? I hope that makes sense. Like, there needs to be a balancing act there. It cannot be completely unreasonable. At the same time, it cannot be that the officer just can't refuse it on that ground.
Right. So the takeaway there, Pushkar, I think in our experience has been, firstly, even in work permit applications, the SUV work permits have a special nature. Officers often get confused, as Alif has noted. We have to explain, ironically, how the program works. We use case law to direct the officer to understand the examination, and then we look very carefully at the particular facts, depending on the country you're from, depending on your financial establishment, your working relationships, your family ties. We have to have a logical explanation and file the application knowing that this program is unique, and officers often get tripped up. So there's a little advanced strategy that I think you have to have, and that way, when you do deal with an officer that makes an unfair decision, unreasonable, as Alif would say, then if we're going to reconsider, there's a process where we've already got really good information on the file. We can often flag that issue, with a third party and explain the issue. And often what we've seen is, knock on wood, within 2 weeks, we can get a reversal where we'll see that the case is continuing to process. But you have to lay the foundation correctly on the initial filing so that you can make that argument.
Maybe we can go on to the next slide. Let's see. Yeah, again, it's along the same lines. It's a number of arguments that you can take to explain why the work permit is an important aspect, and we usually add these into our submission letters or in our reconsiderations as required, or before the federal court. We can move on to the next slide. These are all part of the same aspect of how a work permit may not be refused. This is actually a very important aspect. There's a Rule 89 of the Immigration Refugee Protection Rules. And Rule 89 talks about artificial transactions. Now, you can, of course, read the rule on your own, but what the court has held in the same judgment of 2019 is that, and it's very important to it's very important to understand the context and the intent behind this judgment and what was argued in the court, to understand how you need to advance the argument when you're filing this application, and when you are making a submission to a procedural fairness letter or a reconsideration, or you're just providing regular updates to the business. There is, as the court holds it, there's a fine line between the immigrant being motivated in part by economic motives, and participating in an immigration program primarily for the purpose of acquiring a status of privilege under the act. So therefore, what you as an applicant, or what your clients need to prove is that your motive is to establish the business in Canada, and in lieu of that gain permanent residency, and not vice versa. So you can't really, although you may see a number of these applications being advanced only to showcase that well, we are meeting all the eligibility criterias. We have the checklist here, we have all the documents here, and look at me, I'm one of the best candidates for this program. But that's not sufficient. You need to go beyond that. Your eligibility criteria in itself uh, is not sufficient for the officer to grant you the permanent residence visa. You need to go beyond to explain how your business will create this social, cultural, and economical benefit to Canada, and how you're motivated enough to do this, and how you have the expertise by your past experience to get that and then implement it in Canada to make sure that that business works. And of course, the court also held in the same breath that that significant level of deference is afforded to the visa officer who's looking at this. So the visa officer looks at all your documentation. The visa officer says, okay, fine, you meet the criteria. However, looking at your business plan, which is a 5-page PDF, I don't really feel that you really want to establish this business. And hey, listen, you've been working for 5 years as a manager in a company. Do you really have this expertise to do this in Canada? You're saying that you were a CEO without any entrepreneurial background. You don't have any managerial background. You haven't even managed people, let alone managing a business. So can you really do this? So you need to engage with the officer. And if you are one of those applicants who is a young entrepreneur, like a number of countries are now bubbling up and coming up with 19, 18-year-olds, 21-year-olds. Recently, we were engaged with someone who's an exceptional candidate for the SUV program, just a 21-year-old college student. If you're doing that, then you need to make those submissions to explain to the officer how you are exceptional, and how, regardless of the fact that you may not have relative experience, you are a born entrepreneur, like say a Mark Zuckerberg or anyone else. Noman, if you'd like to add to this aspect of the conversation with respect to, without having relevant experience or exposure, how to place the arguments in your application to make sure that they work.
Yeah. I think what everyone needs to be mindful of is that this provision has often been intended to target those companies where it was pure ideation, it was a fabrication of sorts, and that the officer has become suspicious because of the volume of such cases where they're looking for indicators that people are really looking to get that PR visa as opposed to actually run the business. And because of that experience, officers start looking at warning signs where the individual role, as Pushkar has mentioned, doesn't seem reasonable with your experience, where the nature of the business, we've seen some situations where they start to challenge even the likelihood of this business being successful given information that they've seen generally in the marketplace. So you really are pitching, as mentioned by Pushkar, to demonstrate that this is an innovative business, that you're qualified to do it, that you've got a reasonable approach in terms of how you're going to deliver this in the market, but your activities are going to really sort of contradict the concern of it being artificial. So like, what have you done from the time you got the certificate? What are the richness of your activities? Have you met clients? Have you set up the business in a logical way? And from our experience, when we have worked with companies that are really committed, you would see a pattern of behavior that becomes quite clear. And then occasionally we'll be approached by another client. I had a colleague reach out to me and say, I just received a procedural fairness letter and I've got 30 days. They want to see, what the business is doing, but they haven't done anything because they're waiting to get the PR and then they're going to start. And I said, well, that's kind of backwards. Like, you've got to be starting and demonstrating your plans beforehand. So again, this is about genuineness. It's about being responsible, realistic, and then executing. But this will be a hot topic. I think this is where IRCC will be going, particularly as they're focusing now on the inventory and the adjudications.
Thank you, Raman. We can move on to the next slide. This is a very important aspect. And the question is this. There is a team of 2 people or a team of 3 people. The business has been incorporated. The applications have been filed. Can you add a new member to the business, update the commitment certificate of a business that has been established for a year or 2 years, that has already has some traction, and then have that application processed along with the others? The federal court says, no, you cannot. And it's not about the question. The argument was not about updating the commitment certificate or anything of that sort. The question was only this, that the startup business class program is to start a business, not to join an existing business. So if you are a team of 2 or 3 and you already submitted it, submitted the application is being processed. You cannot add a new member cannot be added to it. Now, of course, a number of things have happened since this judgment of 2022 came in, which we'll discuss later. But the court has clearly carved out that once a business is established, it has been started for a year or 2 years, and there is some traction, you can't join that business and become a part of the startup business class in that business. We can move on to the next slide, Norman. Well, like Alif mentioned, the court has also recognized this as a very important aspect, that the business plan is the key in the startup business class program, because your entire intent, your business, your entrepreneurial skills, the nature of the business, how the business is going to perform in Canada, if the business was already incorporated in another company, and how it performed there flows from there. So all your information needs to be in the business plan. You may even use it in your submission letters to then proceed those arguments before the officer, to let the officer know that you're competent and your business is competent and your business will really impact the Canadian economy. So that's very important. If you don't really do that, then it's not sufficient. And as the court mentioned, which I really like, which I've reiterated in the presentation, that the court says, in effect, it was an idea that was not fleshed out. So you may have a very good idea, but unless the business plan does not show it, the officer will not know. Right? So you really need to work on your business plan to ensure that the officer understands what the background of the business is.
I'll just add one comment. It's just an interesting comment. One night, Pushkar, myself and Alif were looking at a new consult and looking at the prospects for the business. And we were doing some research. We saw an issue that we thought could come up. And we were looking at the business plan. And we looked at some case law. And we noticed that the officer in the case law had noted that he had seen the same business plan, almost identical business plan, multiple occasions being used, and had concerns in that case law. And then we looked at the business plan we saw was almost identical to what they were talking about in the case law. And so in a lot of the marketplace, you'll also see that business plans are just mass produced as part of a process to help individuals get a certificate. But IRCC is very much focusing on business plans, and where they see integrity issues, they can actually start looking to see if there's commonality in these fake business plans as well. So definitely you want to have created and had your hands on your own business plan and make sure it's rich in detail so you can demonstrate that you've got, a genuine intent.
Right. Maybe we can move on to the next one. Yeah. So I want to explain what a peer review process is, because a lot of us, we're going to be seeing a lot more of this process, like Noman mentioned, in light of now the growing inventory and the faster applications being processed. Can we move on to the next slide where I explain actually what this is, and then maybe you can come back. So I want to first explain what a peer review process is, and then what the court holds regarding it. So I'll just read it out so that it makes a lot of sense what the court has held. It says that the purpose of the peer review process is to determine whether the due diligence was performed by the designated entity, and it is not to determine the worthiness of the applications. So there is a provision in the regulation that states that if an officer feels that the due diligence was not performed by the designated entity prior to issuing the commitment to the applicants, then they can refer the business along with the business plan and other details to a group of people who they call peers to check whether whether in their opinion this business would be able to perform well in Canada, and whether the due diligence would have been performed. um, because the peer review process is used by the officers. In effect, what happens is that, let me just gather my thoughts. So the officer refers your applications to a peer review panel. The peer review panel is essentially, a group of industry leaders who check the business and not the applications. They check the business and they check whether before issuing such a commitment, whether they would do a better job at due diligence, or whether they would issue or not issue a commitment certificate. That's the intent behind the peer review process and nothing more. So they can't really dig into the background of the applicants per se and say that they cannot do that. The peer panel does not have that authority. Their limited authority is to check whether due diligence was performed or not.
So they're essentially, Pushkar, would you agree? They're looking to see if the industry standard in doing the due diligence was in fact met. For example, if it was approved like in 3 hours, that would clearly not be what you would reasonably expect thoughtful due diligence to be. Whether or not the business would ultimately hit revenues of $3 million is not their focus. It's about the steps and the process, and if that's what the industry would do for a particular business that's been presented, to make sure that there was integrity in what the designated entity was asked to do by NACO, which is really to use their judgment and measure the the validity of what this process should have in terms of being suitable for the program.
That's right. And in light of that, there are a number of things that the court has held with respect to the process of due diligence. One, the officer may request it. So there was an argument made before the federal court, which you'll see in the previous slide, that the applicant argued that if the officer felt that due diligence was not performed, they should have referred it to a peer review. The court held that it's up to the discretion of the officer whether to review or to decide on their own. And it was also held that the officer is not even bound by the opinion of the peer review. So they may refer it to say that the due diligence may not have been performed, and they may have their doubts. And the peer review may say that no, the due diligence was actually not performed. But the officer may change their opinion later and say that no, I think that it's fine, it may have been performed. So it's completely up to the discretion of the officer. And of course, the peer reviews, the officer can only refer it for permanent residence applications and not for work permit. The work permit, in fact, the work permits are interim, and they are issued much prior to the AORs on the PR also being issued. So even the completeness check does not take place prior to the work permits. Therefore, there is no question of peer reviews being performed. We can move on to the next slide, which has a couple of other arguments that were taken by certain applicants. The officer in one case said that that the business viability needs to be tested in a foreign country, and only then they can frame an opinion that the business will perform well in Canada. Otherwise, how would they know? So the court held that there is no such requirement. You do not need to test a startup in a foreign soil before getting it to Canada, because if that would have been the case, most of the businesses may have not been processed under this program. The intent is to start a business. There can be an established business in a foreign country, but it's not mandatory. The other is that an officer refused the application, saying that that this person doesn't have that level of expertise, which is world renowned. So the court, of course, went ahead and said that, listen, these are entrepreneurs. They don't need to be world renowned experts. We are not looking for experts in their fields. We are looking for people who want to establish a business which may grow in Canada. And that's it, based on a business idea and their background and set of skills. Of course, there's another judgment, the same judgment of Justice Diner, which held that you necessarily do not need to incorporate a business in Canada prior to applying for permanent residency. your intent should be there. So it's not that you have to provide a proof of incorporation, but you need to provide a proof of intent. And there are a number of ways that you can do that, and counsel can advise you on it. But this is what the court has held. Now, if you ask me, is this the best practice? I would say the best practice would be incorporate, put it with your application. You don't want a situation that 3 years down the line, you're saying, no, but the federal court has held that. The officer may not have read this judgment. The officer may not be trained. They have a checklist of their own. So the best practice may be to provide a proof of incorporation, even though the federal court has held that it's not really required. We can move on to the next slide, which has maybe, so there are some case studies that we've seen in our office, and we can walk through them one by one and talk about, and I can take inputs from Alif and Naman as well on a number of issues that we've seen. So I want to start with a very recent case where the work permit extensions from inside Canada were refused on the ground that a business progress report was not provided, updated bank statements were not provided, and a number of other details regarding the business were not provided. So what we did in such a situation is we went back, we looked at what the checklist is. We looked back at the regulations, and we couldn't place a single ministerial instruction or a checklist or anywhere on the website or regulations or the act that says that you have to provide a business progress report. So the client came back to us and said that I did everything that I had to do. I mean, the IRCC website says this, and I've been very thorough. I've been watching these kind of seminars in which lawyers like you have spoken about these aspects, but this was not clearly put anywhere. So a simple answer to that is that everything that you need to add in your application for an extension or any other application is not really carved out by the IRCC in their checklists or on their website. There are certain nuances that we know from practice by looking at these refusals, such as you need to provide 4 to 5 important documents to make sure that your work permit extension is approved, such as you need to provide a business progress report, you need to show your activities. So we have an activity tracker to do that, and Alif will cover that in the coming slides, where we show exactly on the date on which you met a salesperson, on the date on which you pitched this to a client, and a number of other activities that you had performed. And you need to provide these updates to the immigration officer while saying that I had entered Canada in 2022 December. Since December 2022, I've had 15 meetings with these clients. These were the dates of these meetings to show a business update, to show that you are actively engaged in the business. And we did that, and we of course received an approval right on reconsideration. But it's rather better to be proactive, in our opinion, to keep providing these updates on your PR applications also, so that by the time the officer gets to it, after a period of 3 years, they see that, listen, these guys have been exceptional in their business. Every month they provide us with a monthly update on their business, or every quarter they provide us with updated financial proofs to show this is the amount of business they've done. And that doesn't have to be, your company doesn't have to become a unicorn in 3 years. That's not the expectation. The expectation is that you are progressing. The progress can be slow depending upon various factors, such as what your business is, how well it can perform, other certain factors, the political scenario, a number of others. But you need to be actively engaging in it, and that's the test. The intent is whether you are engaging in your business. The other one of the other cases is sorry, we can go back, Narmin. I'm just going to cover maybe a couple of other case studies, which I think are very common these days. So an application was filed, a paper-based application in 2022, right? Because at the time these weren't done online. The portals weren't created for the startup business class. Once the applications were filed, until 2023 there was no update on the applications. In 2023, the officer the applicants received an AOR on email, on the representative's email, and then they started communicating through that email. Now, unfortunately, the representative's emails inbox was mostly full all the time. So there are a number of email communications that was sent by the officer to the representative, which the representative at time did not receive. And the ones he received, he forwarded to the clients, got the information and provided it, right? So the officer ended up sending a request. The applicants did not receive it. There was a PFL sent. The PFL, they replied to it stating that they may have missed the communication. The officer refused it on the ground of A41 IRPA stating that you did not comply with certain provisions of the Act by not responding to my queries. Now, because that person was an essential member, the other members were also refused on the same ground that one essential member has been refused. We were engaged. We challenged it before the court, talking about certain procedural fairness aspects of how the communications were missed, the number of case laws that establish of how the communications need to be sent, and how what is a deemed receipt, or what is, or how the courts have interpreted as to if a communication is missed, then who is at fault, who has the onus to prove that they had sent or received a communication. Now, thankfully, we received a favorable outcome for a client within a period of 2 months. Now the applications are reopened, and of course, further documents are being issued. So this is a very common theme that we've noticed in the past: missed communications, a number of communications being sent by the applicants or by the immigration officer. Well, another such was very recently of certain some of our Iranian clients, and we have in which a prior refusal was not disclosed. Now that application was refused, but the other 3 team members were also refused, and these applications were filed sometime towards the end of 2019. So it's been a very long time for them. Now, unfortunately, the applicant could not really provide it because they weren't really in receipt of such refusals. So we could argue certain procedural fairness aspects, and thankfully the court understood it. So did the respondent, and on consent we had it turned around, and these applications are now being processed. There is one other very important aspect that we've noticed, and we think that it may not only impact certain groups of people but nationalities. We've noticed that currencies keep fluctuating. Iranian currencies in particular, we noticed there was a 65% drop in countries like Nigeria, where suddenly the currencies dropped. Now, you had provided our clients had provided proof of funds to show that they meet the criteria based on the funds that they have in their country of residence, in their bank accounts. Right now, the currency fell, and as soon as the currency fell, the applications at the time were ripe to be opened by the immigration officer, and they started processing them. So then some of those applications were refused, and in some of those applications we had to jump on them before they were processed and provide updates to proof of funds to ensure they are not refused. So the intent behind putting this in the case study is that you need to be proactive as an applicant, and you need to be even further proactive as a representative. It's your responsibility to provide all these updates to the clients, to ensure that the client is aware that it's your proof of funds are not locked in, like your age may be, like your children's age may be in the PR application. The funds, the currency rates keep fluctuating, and you have to be on top of it to ensure that when these applications are processed, then the LICO is met. That's very important.
Alif will be actually commenting because there are new updates, right, to the LICO, and the settlement funds have been increased that a lot of people are not aware of. I think in the interest of time, Pushkar, let's do this. Nermeen, we can move forward past the next section. So if you keep tapping, that was really a discussion about how even when we see clarification from IRCC, in fairness to IRCC, sometimes they don't get the right answer either. And it's because some of the policy is very uncertain. So we've seen issues where they did believe that an open work permit for 3 years could be issued when in fact it's not the case, and a few other comments. Point being that a lot of the clarity is gained through experience, and you have to make sure you double check any information you get. We can move over to slide 31. And maybe why don't you, Alif, you can do a little bit wind up about some of the top strategies that we've discussed today, and then the activity tracker, and then I'll do sort of the conclusion. We can open up for questions.
Sure. So yeah, just in the interest of time, I'll breeze through these. Just in summary, it's more important now than ever to be prepared, because your application, we anticipate, is going to be processed quicker. And so typically, once you get your AOR for your PR application, you also receive a list of questions. I have a feeling that those list of questions are going to be a lot more thorough. And it's going to have a lot of detailed questions and pointed questions towards your business and your activities. So it's important that you anticipate these questions early on and really try to establish your business and grow your business in Canada early rather than later, so that you can adequately answer these questions and have your PR application processed quicker. The next thing is a health check. So since your applications are processed over a certain duration of time and you're continuously doing activities for your business, it's important that you always reflect back on what was submitted with your application and how you can check the health of your application by continuously updating the application. And so part of that is, as you mentioned before, updating and revising your business plan based on the Canadian market, based on whatever you're seeing happening right now in trends in your relevant market and your target market. And so if you see that there's one area that you want to lean towards rather than going in a different direction, then you include in your business plan. You provide projections based on that. And so a health check is best practice, just to continuously see where you're at in the business and where you're going to go as well, and always update IRCC accordingly.
And I'll make a comment on the health check, Alif. We've seen a lot of times we've been retained when things go wrong. And when we look at what was filed, particularly for individuals who were not represented by anyone, they looked at the checklist and they thought that was enough, but it was a very thin application. Often the business plan, which the federal court, according to Pushkar, is quoted as the most important document, was not included. So how could the officer have a fair chance to actually understand the business? And if that was filed 37 months ago, you're asking for trouble. So for those of you who have not had an experienced counsel, you might want to just retain, a professional to determine whether you're okay. It's like, I always say, we use the term health check. Prevention is the best medicine. So go up early, get a check, see if you need to do anything. The benefit is, until a decision is made, new information can be presented, which can fill the gaps. So just a comment for those, if you haven't had some advice, it's never too late to get the advice, particularly when we know that they're turning to adjudications now.
Right. And also to add to that, we've also been retained at the 11th hour, where we anticipate that the officer is going to refuse this application. We've recently been retained for answering a PFL, right? And so you really don't want to get into a situation where you have to reach out and retain counsel at the last minute to save your application. You really want to do it preventatively and do it earlier on, so that we can intervene, make sure that your application is healthy, so that you can avoid any future PFLs or concerns raised by the officer. So again, just always time it in a way that is beneficial to you as well as for your immigration lawyers, representatives, so that we can really work with you and try to strengthen the application as much as possible before it reaches that stage of processing. Again, part of that is monitoring your business activities as well. If I think we can go to the, or no, it's after this. I'll get to the activity tracker in a bit. But monitoring your business activities with really fine detail is important, because the officer may ask follow-up questions, which could lead to PFLs if you can't adequately answer them. So, just having your own tracker, or if your representative has a tracker to use, you should always review it on a daily basis and include supporting documents as well. For example, if you had a business meeting where a lot of things were discussed that were very promising for the future of your business, it's important that you also kind of document that meeting. So if you have notes from the meeting, if you have any correspondence and emails that you can show the officer, it's very helpful to provide supporting documents for your activity, so the officer knows that, and they can see and they can verify that these are genuine activities and they're not just, you typing something out saying that you did this when, in reality you may not have, right? So a lot of it is also just kind of bolstering your application and supporting evidence that you can provide to IRCC. Addressing material changes, again, like if there's a big change that's kind of diverting away from your certificate or your business plan, it's really important that you consult with an immigration lawyer or a consultant, because the material change, it could cause some ripple effects on your co-founders or the certificate and your application in general. So this kind of goes hand in hand with the health check as well. If there has been a material change, you do have an opportunity to inform IRCC and work with the officer to make sure that those changes still ensure the success of your business and they don't actually take away from it. And if we go to the next slide, Another really good point is to know your designated entity. Noman touched upon this before. There are a number of entities who maybe don't do that thorough due diligence, which could be a big problem for your application, right? So it's really important that you monitor the status of your designated entity, make sure they're still listed as a designated entity, because some of them could be removed from the list and you may not even know. And so if that happens, then that's a whole different issue that you would have to tackle. And so it's important that you make sure that you're in constant communication with your entity, and that that you're very comfortable with the security of your application and your certificate. There's, I think 82 listed on IRCC's website. So there is a lot to pick and choose from. So it's important that you really discuss it and have a list of questions ready for your entity when you're having that conversation with them. Expertise to address challenges. You should always seek appropriate expertise when responding to PFLs, additional information requests, and even simple document requests from IRCC. Something as simple as a information request for your business updates, it could end up potentially being a PFL if the officer is not satisfied with your answers, or if you haven't provided enough information to appease their concerns. So even if it might just seem like a simple letter, it could end up being something more serious. And this is kind of what Pushkar and Noman were talking about with the IRCC phone call, right? It's the exact same thing. If the officer calls you and they're friendly and they're getting information from you, you probably think it's just a normal conversation. She was very polite, but it turns out that, the very next day he gets a procedural fairness letter and, the application is very close to being refused. You don't want to be caught in that situation. So any correspondence you get from IRCC, it's very important that you really make sure you reply to it with as much information and relevant information as possible to appease any of the officer's concerns. Planning, again, this goes towards the material changes in your business. You really have to plan out your business and make sure that your business plan is thoroughly fleshed out, like what one of the case laws mentioned. It has to be very robust, very detailed, and it should provide the officer with a very clear direction of what your business is and where you're going to go in the future. The new reality of SUV is it's going to be challenging to get letters of support if you haven't already. And so it's very important that you put your best foot forward and you really present your idea to the incubator or the entity so that you can increase your chances of getting that certificate and getting processed. If we go to the next slide. This talks about your status as a worker. I mentioned this before. You really should try to apply for your extension early so that you preserve your status. You don't want to be caught in a situation where you're out of status and have to restore, or even if you're on implied status and you may have to travel out of the country for emergency, you won't be able to come back with worker status, right? So it's very important that you monitor the expiration of your work permits and apply accordingly. Commitment certificates, again, it's your golden ticket. You may not be able to get a second one if your application gets refused. So it's very important that you make sure your application is perfect and that you continuously update it as processing continues, because you only have one bite at the apple now. Updated business plans, we've gone over this a few times, and being proactive, again, you're going to get those letters very soon. IRCC is going to process quicker, so it's very important that you track your activities. You make sure that you're doing as much as possible instead of sitting and waiting for your PR visa, because it may be that the officer asks all of these questions and you're not ready yet, right? You may not have done enough. And so you don't want to be doing 1,000 things within 30 days to respond to the letter. And the next slide is our activity tracker and the importance of this. As you can see, this is, sorry, go ahead.
Do a very brief summary of the activity tracker and the settlement funds, because I know that we are getting a little light on time and we do want to sort of connect with the audience.
Sure, no problem. So the activity tracker, this is just a sample one that we provide to our clients. It just has a list of activities that you're doing. It has a date, some details, as well as a supporting document that you can upload. So this is just, a very brief overview of it. You should seek to do something similar, because what we do is we just provide this entire tracker to the IRCC officer who's asking questions, and they'll be able to see line by line, date by date, what you're doing with your activities and what you're doing for your business. So this is very helpful for the officer to review. If we go to the next slide, these are the new support funds requirements for the work permit application. Interestingly, on the left side, you'll see the previous chart, which was listed on the ministerial instructions. And the chart on the right is what's listed on the SUV work permit website, which most applicants go to when they're looking to apply for a work permit. The one on the right has been updated on June 3rd. There's a change in each number of family members and how much you're required to show for your work permit. So this is just something to be aware of, that there are sometimes discrepancies in information, because the one on the left is what we typically look at when we're looking at the A77 category for work permits, but they haven't been updated yet, right? So if we get caught short by $1,866, then that could be a big problem. So it's very important that you make sure you check each and every single piece of information available to you when you're looking at these applications and preparing your applications. The next is the new investment funds requirement. This is kind of important because this was added this year, I think in January, at the end of January. The applicants must also show investment funds, which are separate from your personal proof of funds. The reason is that the officer wants to make sure that there is enough investment being made by the applicants to the company. If you have a group of 5, let's say, the officer will want to see the contributions of each member based on their relative ownership as well. There's no required amount that is stated in the regulation or the instruction. It's more of a reasonability test that the officer will make. So if they see that, you know, all 5 co-founders are each contributing 25%, maybe 25,000 each, something like that, then it's reasonable, right? So you just have to make sure that you include information about what kind of investments are being made in the company by each member and their own capacity. So that's just something to be aware of. This is specific for work permits. Settlement funds on the next slide. These were updated June 3rd. This is very simple. I think it was increased for all PR application types. So this is just something that you should be aware of. And next we have, I believe, Noman, I think you're going to tie all of this in. Yeah.
Second wind up. So one very important clarification, the program is not closed. It's capped. It's a temporary measure, right? And during this time, they're going to try to reduce the backlog, and they're going to consider redesigning the program. We've had discussions with them. They've had some interesting thoughts. It's going to be an evaluation. I can tell you personally, talking with a couple of senior directors, they pointed out specific companies that have come out of the program that have done really well. So they're supportive of the program, just not the current state of the program. Hopefully what we'll see is a stronger program with more integrity that will match the original intention. We've seen some great companies. I think we've had over 5 that after coming to Canada were identified by significant VCs and got major funding and are onto great things. So there's definitely some wonderful use cases here. Hopefully what we want to see is that the policy is clearer, that the policy and the regulations are aligned, because right now they're inconsistent, and that they develop a process that meets the intention. I think the designated entities will be under a little bit of examination during this time to make sure that they're doing their part. So hopefully there was value. I think we covered a lot of ground, Nermeen. I think we really looked at a lot of issues, and hopefully the audience, those people who are involved or interested, know better from today what to expect. And yeah, we're always here to help and always looking forward to collaborate with Nermeen. She's one of the good players in the market, and we enjoy collaborating, and she's always wanted the best intention for the program too. So you're in good hands if you're dealing with Nermeen.
Oh, thank you very much, Nauman. I really appreciate Nauman and his team. They are very, very well-reputed immigration lawyers with morals, with ethics, and which match exactly what we look forward as at North Forge. So before proceeding with the Q&A, you know that we're going to take more of your time.
Yeah, we're ready. Yeah.
So because we are now flooded with the questions, and we want to make sure that everyone has an answer. So one question says, which visa type is appropriate for my wife if she apply for a visitor visa? How long is visit visa valid? And is it possible to convert it to work visa after arriving in Canada? So basically it's about the wife and the children and what is the different children's ages.
Perfect. Alif, this is usually a question you probably see a lot.
Yes. So typically you have 2 options for those. One is you can get an open spousal work permit, which will be made valid to the duration of the main applicant's work permit. So if you get 1 year, then she will also get a 1-year open work permit. So she'll be able to work for any employer in Canada as an accompanying spouse. For the children, if they're over the age of 6, they can get study permits. If they're under the age of 6, then they can get a visitor record, which is essentially a status document that allows you to remain in Canada as a visitor to accompany your parents while they're here. Spouses could also get visitor records as well. We typically submit work permit applications for spouses just because you have a added benefit that you can work if you wanted to. I believe it's a little bit more secure to have your spouse be able to work, just in case, maybe the startup company doesn't generate revenues just yet. It might be nice for you to be able to lean on your spouse a little bit because she can work for anyone.
Interesting. So when they apply for their children and for their wife, do they have to embed the letter of support as well in their application, or it's only for the main applicant?
So it's only for the main applicant. Typically, we file for the whole family together. So the processing happens together as well. The same officer is going to look at the entire application. So as long as the main applicant has the letter of support and all of the required documents for SUV, then the spouse would just have to show that she's married to the main applicant. The children would have to show that they're, the actual children of the main applicants, right? So you have to just link it, right? So birth certificates, marriage certificates, and then, your regular passports and proof of funds, et cetera. So whatever else is required for that particular visa, you would submit it. But the letter of support is specific just to the main applicant.
So
That's exactly correct. Our best practice is it's better to file everything together. We have seen where the main applicant gets the work permit, and this happens in other categories. Lately, when dependents try to come in, there's interpretation issues, or really shouldn't be. So ideally, best to put them all in together. But if not, once the primary applicant gets the work permit, it's really about proving the relationship and then filing the work permit, and then they can join.
Interesting. Then you have answered the question that I wanted to ask. So the other question is, does North Forge, okay, this is for North Forge, have an updated, okay, now we're going to go to the North Forge. So for North Forge, I just want to make this because lots of questions about North Forge. So at North Forge, we are posing applications now because we need to reevaluate the program. We need to reevaluate the processes with reputed people like Nauman and his team and other, IRCC and other, stakeholders. So we are now posing, we're not accepting any applications, but we are open to communications and questions. So the other question is, you already answered about the children. So the children basically and the family, they don't have to apply or to have any letter of acceptance or letter of enrollment or registration for the wife and the children. It's enough for the main applicant to provide all the applications and all the documents, and just to prove that they are their dependents, right?
So it depends on where they're currently located. So if they're in Canada studying, you would have to show a letter of acceptance from or enrollment in a school in Canada. But if they're applying from outside and the applicant hasn't traveled yet to Canada, then you're actually exempt from providing a letter of acceptance. You would just have to show the relationship at that point.
Also, I'd like to add this question. There's actually more to it. There are certain study permit regulations that were recently amended, and unfortunately these amendments have been taking place for the past number of years, and there are so many new regulations. So it depends completely on the facts of your case. There are 3-4 exemptions, such as people applying to study for a master's degree if they are outside Canada, if they're accompanying dependents to a principal applicant, and if you're talking about minors, it's a different thing. If they're inside Canada and they are in school and they are enrolled in a school and they're studying, that's a different thing. So it'll completely depend on the facts of your case. So just reach out to us, send us a short email, give us a fact summary. We'll let you know what's the best process. Do you need a letter of acceptance from a university, or do you need to show proof of letter of enrollment in a school or not?
Yes, that's amazing that you have mentioned that, Pushkar. We just need to clarify that all what we are discussing in here is just like an overview answer. So more details are required for the specific answers. And again, as Pushkar said, that you are welcome to communicate with them directly. So again, this is a case that we have already discussed, is that when the applicant, he applied for himself, but he didn't include a family. So I believe Norman already said that the applicant, once you get your work permit, you're gonna apply for your wife and your children, right? Pushkar, Alif, and Norman, right?
That's right.
So the other question is, will you share the record? Oh yeah, we will share the recording and the presentation. It depends on the presenters. If they give us the permission, then we're gonna share the presentation. Other than that, it's only the recording will be shared with everyone. So then we answered this one. So the other question is, if a letter of support was issued in 2023 and expired before all applicants could, and all applicants didn't apply within the 6 months, can the commitment certificate be updated without it being considered as one of the 10? Okay, this is a very critical question. It's just like not only an applicant question, it is our designated organization. And we have raised this multiple times with IRCC, because now we got this answer from the IRCC. It's not clear yet. So I cannot issue a letter of support for anyone or any commitment certificate because the regulations are not clear. So Pushkar or Alif Nauman, do you have a specific answer for this around reissuing letter of support or any edits in the commitment certificates within the new regulations?
I'll let
It
you
would,
take this one, Naman.
yeah, so I'll start the discussion. And like you said, I mean, these are areas that are not really clearly defined. So it's more of a discussion than a definitive answer. I would think now if a brand new certificate is being issued post April 30th, it would be very hard to take the position it should be counted against the non-cap provision. I mean, that would be the reading of the announcement, unless they carve out some exception. So that's my initial impression is I would think you'd be caught by the cap. I don't know, Pushkar and Alif, if you agree or disagree.
Yeah. So if the sorry.
No, go ahead. Yeah.
Okay. If the question is that the LOS was issued in 2023 and expired before all the applicants could apply, I'm assuming for permanent residency at the time, then can it be amended or not? Now at this stage, well, it's a very gray area, and I would highly recommend that you take counsel. We want to take a step back and talk about three major points here. One, the regulation is silent on updating or amending the commitment certificate. It does not talk anything about it. The only requirement under the regulation is that, well, something that you did not do, but you should have filed the application when the commitment certificate was valid for a period of 6 months, right? Whether you can amend the certificate or update the certificate is something that up until, well, 4 weeks ago was a matter where you could argue that yes, it's been updated and now this is what we've done. However, there are two significant changes that were recently announced. One, there was a cap, and what that cap did is it introduced a certificate number, and then it gave a clarification saying that if they do not use it or for somehow it cannot be done, then that certificate will expire and then you have to issue a new one for the designated entities and for applicants. In your case, it is dated 2023. But the designated entity may not be able to issue you a new one because any new certificates that they're issuing has a commitment certificate number to it. So whether they can amend the previous one is a matter of contention, because recently there was an update on the website, which we may or may not agree with, that says that the commitment certificate can only be amended or updated prior to filing the permanent residence application of any one of the essential members. So in a situation where Nermin, me, Alif and Noman are four essential members of a business, and all of us have been issued a certificate by North Forge, and Nermin has filed the permanent residence application. Then what the IRCC has said on its website is now the certificate cannot be amended or updated anymore as soon as one of the essential members file the application. So that's what it is now, which we may or may not agree with, and it's a matter of argument that you have to lead depending upon the facts of each case, what prejudice can be caused to a particular applicant. But in your case, you may have an arguable case to make subject to the circumstances as to what prevented you to do it. But there is a regulation that says you must do it within a period of 6 months. So you'll have to argue against that regulation.
It may be difficult, like from the perspective, updating and amending is usually on a valid certificate. When the certificate is expired, that raises another challenge there. But definitely, I know that there have been a number of questions even about certificates around that period of time when the announcement came that were not yet issued and couldn't be issued in time, how those will be dealt with. So definitely an area for review, because one of the biggest issues is there's a gap. A lot of these policies are in place, but there's no regulation that speaks to it. And we've had those situations on other issues where when we responded back to an officer that was about to refuse, once they saw the legal contradiction of the regulation really not speaking to the issue and policy being introduced without the support, we were able to get a positive decision. So long story is that is an issue that needs to be looked at. It's not clear yet, but we're taking a look at.
Exactly. And it's very critical for us as well as a designated incubator. That's why once they announce this one, we have sent a very sharp, strong worded email to all our applicants. It's your time to apply, because nothing is clear and we will not be able to issue any letter of support or commitment certificate. And even the editing of commitment certificate is very critical, because we're in direct relationship with IRCC, and I believe Nauman and his team as well. It's really critical under the flagging at this stage. So the other question, again, it's for North Vosges. Well, this will be changed. Everything gonna be changed, but nothing is clear yet at our end. And we will announce once we are ready to accept applications. So the other question is, when the essential founder is applying for the work permit, what visa? Oh, it's again for the children and the wife. It's either visiting or study according to the age of the children. It's a specific case by case thing, and the Bushkar and his team and the Nauman and Alif invite you to send them an email for a specific case. So what will be your program? Okay, again, what will be? It's again our program. We will announce everything once we are ready. The other question is it possible to make a change to a team that has been issued a letter of support but has not submit the PR? For example, add a person and issue a new letter of support. Have you done this? What are the negative and the critical point? Again, it's the same thing, Norman, right?
It's theoretically, the way that new policy, if we believe that the policy is valid, we can amend a certificate or update a certificate until one person files the PR application. So if there is a change and the application has not yet been filed, then it is possible to update the certificate. We have seen that happen in the past. Now, of course, anytime you're going to make a change, it has to still be a suitable business proposition, that it doesn't change the merits of the case, but theoretically you still have room. You're locked in under the new policy once you file the PR application.
100%. Okay, the other question is, okay, this one we answered. They are telling you when is the okay, we have already submitted. Oh yeah, this is very important, and I have been asked this. Can you please, any one of you, just like put in the chat the link for the web form when they want to have any updates, any something. I know it, but I was afraid to share it with the applicant. I said, okay, let's ask the expert. They're asking about what is the best way to communicate with IRCC for any updates, if there's any missing documents or something. So please, if any one of you could put in the chat the dedicated web form link. So the answer is via web form, right? Norman, do we have any other answer? It's a web form, right?
It can be done by web form, particularly if you filed or you have a representative, they can reach out directly by web form. Where we're dealing with certain designated entities, there's also ways to deal with IRCC through the designated entity if there's like an issue that needs to be clarified. But yeah, typically through web form is quite common.
Interesting. Okay, so what do you think of the future of the SUV? Everyone is afraid, Norman. I know that you have emphasized multiple times, it's not canceled, it's not, but yeah, everyone is worried because of the different regulations. So if you just like a pre-fit, again, just like to calm everyone, what do you see about the future of the SUV?
It seems from the discussions we've had with the policy directors that they do see the value in the program, but I think we won't see high volume. I think this will be a more measured program. I think what we're going to see is more scrutiny on the designated entities to be more thoughtful and careful about who they select. That's why they're starting with 10. If you think about it, it's very visible after a year to look back at the 84 designated entities and see which companies, what type of companies did they actually validate? Like, were they appropriate? If it turns out and the market speaks that a company is charging, like I've heard some ridiculous numbers where they're charging huge amounts and they're issuing it to ideation companies that have no track record, that wasn't what the program was intended to. So I think hopefully what will happen is it will create competition amongst startups to really develop a great idea, not just a quick idea and get a certificate, and try to make the case like you would be pitching in real life. If you're going to get investment, you have to have a compelling business. And I think we want to see a higher standard, designated entities issuing the right types of companies that, at industry standard levels of due diligence. So I would think if all goes well, there will be a program, it'll be more selective. And I think individuals who are trying to find a way in and we're not genuinely committed to the business, I think they'll be deterred because they won't be able to get a certificate. So I think it will live on, but in a more modified way.
Interesting. Okay, so the other question is, will the new role of the startup visa program affect the reissuing? Again, we answered the reissuing of letter of support. It is very gray area, and it's going to be red flagging for both maybe us and the applicants. So now we are posing even reissuing letter of support. So the other one is, I'm planning to visit Vancouver in August, as I will be meeting financial consultant and IT developer in PC and Calgary. Should I apply for working visa before my trip or inform authority for issue visa? I don't understand the question. Do you understand the question, Pushkar, Alif, Nauman? So he's coming.
I think we probably need to know more context, like if he's in the program, if he, where he's at, what his goals are, what his activities would be. One has to be careful. If you're engaging in activities and if you think it might turn into actual work, then you need a work permit. If it's generally coming in to assess potential opportunities, that could be a business visitor action. If the person had a certificate and was ultimately going to get a work permit, these might be a good activity to be doing under the work permit. So I think, again, we need to know the context, and then we could make a good decision as to how to get proper admission to Canada accordingly.
100%. So the other question is, I think that you touched on that. Can an essential team member, for example, the CEO, apply for a PR through additional streams? Just to confirm, Naman and the team, I believe that you said if the essential team member has been accepted for a PR in a different stream, this will mean, I'm not going to complete it.
Yeah. Okay. Under the new policy guideline, if an essential member is approved for PR, the officer can basically wait to determine if the rest of the team is approved and then process the PR for the CEO. So theoretically, it can be done, but we have to make sure still that the merits of the case are still met. So it doesn't mean that the officer won't look at the entirety of the case, they will, but it means that if an individual is able to get PR, let's say through express entry, as long as they're still actively involved in the same capacity, working as a CEO in that SUV business, and everything else checks out, meaning that the business is strong, due diligence was strong, the officer is convinced that it meets the requirements of the program, the mere fact that they've been selected for PR in another stream is not going to be an issue, whereas in the past we saw that it resulted in a refusal. So we think this is actually a good change. It means I've had some clients who have said, hey, it's taking like 3 years. I'm now in Canada, I'm doing work, and I graduated, and when I see my CRS points, I think I could get selected. In the past, we'd say you have to be very careful about that, because if you get approved, everyone else will get refused. This policy seems to suggest the opposite, that you can go ahead and do it.
Interesting. So the other question is, is it possible to provide a proactive report for your PR without first receiving the AOR?
Yeah, you can. Well, I mean, so Alif, just one of the issues is the communication piece of that. But in terms of time stamping your activities and making sure you're showing from the earliest stage that you have recorded and done it, you can. I'll sort of turn it over to you about sometimes the difficulty of actual communication.
Sure. So typically, if you wanted your updated submission to go to IRCC, you're submitting a web form. You usually need an application number to link your submission to your application. Generally, AORs and the application numbers for PR are not being issued until well past 12 months. And so the way that we go around that is you can still submit a web form without including an application number. You could use your UCI, your unique client identification number. And so once you've done that, it'll just kind of sit there in limbo somewhere with IRCC. And then once they've opened your file, they'll be able to see all of the web forms that you've submitted. And then at that point, IRCC, they would be able to review and process the new documents that you've provided. But also, I would also make sure that you keep a track of all the web forms that you've submitted and all the documents. And then once you get your application number, resubmit the web form again, just for good measure, because it is possible that those web forms might not end up being linked to your application as well. So until the officer actually opens your application, you do still have some time, right, to actually do your business activities and provide updates. But I would also compile that into one larger document and then be able to provide all of those at the same time when you get your application number.
Yes, I'd like to add to that. There may be a situation where you submitted an application and forgot to upload a document, and the officer gets to it after 2.5 years and returns it on the ground that you did not submit it. So one of the ways that you can get past that is submit it via web form, keep a record of it. Tomorrow, if it's refused, then an argument can be made, because the federal court has held that up until the application is being processed, you can keep updating, you can keep submitting the applications, the additional documents to IRCC. That's a very important aspect of this. Keep that in your back pocket whenever you are, whenever the application is being processed. You can continue to update the application.
Interesting. So another question related to cost of the Nauman Hamid group. So I believe anything related to the cost and the operation, I believe that you have all their contacts, and I will, after this presentation, I'm going to send email to all applicants and to all the audience with the presentation and with the recording and all the information. So I believe that for the cost of their services, it has to be one-to-one via email. So the other one is, sorry?
Many people are interested to know what Greenberg Hamid charges.
Yeah, exactly. So the other one is having the business patent, is having the business patent mandatory? What is the letter of agreement? Who provides this document? Okay. So it's a multiple questions. So I think that he's mean the letter of support. So it's by us as a designated incubator. But the first question, the team, they are asking about the patent of the business. Is it something mandatory to be accepted?
The patent is not, again, let's go back. Whenever you want to answer a question, you look at the regulations. Regulations and policy do not state that you must have a patent. Is it helpful? Is it, does it show innovation? Is it an indicator? Absolutely. So I would say personally, and I think when you go looking forward, I think when you're doing due diligence as an entity, that's probably something top on your mind, is how do you know that you can protect your innovation? So I think it's relevant. It's not absolutely necessary. There might be circumstances where you develop a model where you don't have a patent, but there's something unique about how you do business where you can work around that issue, but you should address it. And your counsel should be thinking about how do you demonstrate that you meet the level of innovation without a patent. So it's a relevant consideration, but not a mandatory requirement per regulation and policy.
Interesting. So the other question, I'm going to say it. I know the answer because we have asked IRCC this, but I want to share it also with the team and with the audience. Is this fasting processing limited to funding from incubators, angel investors, or venture capital listed on the IRCC website, or can it also apply to fundings from other investors non-listed in IRCC? So basically, this is unfortunately some, I'm not going to mention who, but it is some incubators, they are promoting for applicants, go get investment from whoever and come apply to us, and then this is going to be a faster track. And we have asked, this is a no. The only funding that you're going to be accepted as a faster track is coming from the designated entity that is mentioned in the IRCC. It has to be either a VC or angel investor or one incubator from the designated who offers this investment, which is very limited, or one of the CTN. I'd just like to confirm with you, Nauman, and the team.
That's our understanding too. I mean, the last thing when you step back is IRC would not like to see more schemes of trying to demonstrate funding for the purpose of getting faster processing when they don't even know where the funds are really coming from. They're not from a designated entity. So I think that's entirely reasonable in line with their new thinking.
So the other question is, there is a rumor that the VC angel invest the applicant using client's fees from the applicant. Is that fraud? Oh, I think that you are very familiar with this case, Norman. We have discussed this before. So they're asking about the VCs and angel investors when they use the money of the applicants as investment. So I know that you are having experience with this, Norman.
Yeah, I mean, it to me, that doesn't seem acceptable or in line with policy. The idea is that the VC or the angel sees the merits of the business and they give the money to be able to help fast track the company to grow, not to take the money of the same person and give it back. I mean, that's a simple way of explaining it. To me, it doesn't pass the smell test.
Interesting. So basically, these are the questions that I have seen in here. The other are all about the cost and our when we're gonna proceed, and we will decide. I have one specific for one client, one specific question that was sent to me via email. So he said that I tried to do a flag pulling and applied for the SUV work permit at the Pacific Highway Port of Entry. The officer wasn't familiar with the SUV program, so she looked into the IRCC document where it said A77 category SUV work permit was ineligible to be applied at the port of entry. He's
Yeah.
not sure if this is a recent change since he heard cases of applying for work permits at ports of entry. I had to come back to applied online following the way, applied inside Canada. It says it said that the processing can take months and applying from inside Canada even slower than from outside Canada. Is there a way to speed this up? So maybe it's a two questions. How can they get the work visa or the work entry ports as an SUV applicant? And the other one, is there any way that they can faster process the work permit application?
Alif, maybe you can take the question on the procedure of applying at the port. I remember discussing this.
Yeah. So I'm not entirely sure if it was newly put into the ministerial instructions, but as far as we're concerned, you cannot apply at the port of entry. You can apply at the port of entry for certain types of work permits, and there's certain requirements and eligibility criteria. But specifically for SUV, you cannot apply at the port of entry. That being said, it has to be applied online, depending on where you're located or your country of citizenship. Now, if you apply and you're looking for a way to expedite processing, there are a few ways that you can do it, but there really isn't a guaranteed method that'll get you expedited processing. I think Pushkar Naman, if you would like to talk about those different ways that you can get it.
In some instances, so when you're in Canada, then you either file the application, if you have status, you can file it inside of Canada, you could file it at New York, or you could file it in your country of citizenship. You have the right to do that. So you can look at the different processing times to see if there's a variation. And then when you file the application, what's important, anytime you're seeking for expedited processing, it's discretionary, number one. Number two, it's based on the merit. So is there a rationale? Is there a position that you've taken in terms of, I'll give you an example. We've had some companies where they're in the midst of innovation involving a province, where they're working with a province on something that could be really significant, and there's a timeline, there's regulatory changes. So we're asking because of the specific impact that is going to benefit Canadians. And so that allows us to articulate it if the business is potentially in some sort of essential service where there's an argument that it deserves faster treatment. So you can make the request. Unlike the US has something called premium processing. You pay and you get faster processing. Canada doesn't have that, so it's based on individual request. You should draw attention to it. We typically, where possible, we work with the designated entity to try to communicate where it's a deserving case. And then we sit back and hope for the best. But, occasionally we can get better traction when we've got good facts to work with.
So I'm done with all the questions. As I said, the rest are for about your operation hours. They can reach out via email. So I would like first to thank you very, very much for this informative roundtable. We will make sure that whenever anything happens new, we're going to do another one so that we keep everyone informed. And now we're going to move to the networking. I know that we have taken too much of your time, so it's up to you how much time you're going to provide for the networking. Nauman and Hamid, just keep me updated via chat. And everyone, if you want to talk to them online, one-to-one, you're going to find them in their tables. There's lots of tables, maybe Nauman, Pushkar, and Ali, if maybe we're going to go to different tables so that
Sure.
you can communicate with more people, okay? So thank you very much, everyone, for being with us, and thank you, the team, and have a good day, everyone. So let's go to the floor now.
Yeah, we look forward to meeting people in the networking session. Have a great day. Okay.
Yeah, you too.